हेलो एवरीवन। इस वीडियो में हम बात करेंगे टॉपिक 7 के जो भी केस लॉज है आपके सिलेबस में दिया हुआ है बिजनेस रेगुलेशन जो 5th सेमेस्टर ड्यू LLB के कोर्स में पढ़ाया जाता है। टॉपिक 7 बात करता है टेलीकॉम रेगुलेटरी अथॉरिटी ऑफ इंडिया एक्ट रेरा, ठीक है, 1997 का। इसके केस लॉज हम स्टार्ट करते हैं। इसमें पहला केस है सेल्यूलर ऑपरेटर्स एसोसिएशन ऑफ इंडिया एंड अदर्स वर्सेस टेलीकॉम रेगुलेटरी अथॉरिटी ऑफ इंडिया एंड अदर्स। सुप्रीम कोर्ट केस डिसाइड हुआ था 11 मई 2016 को। इस केस का फैक्ट है ट्राई इन ईयर 2015 was amended by the Telecom Consumer Protection 9th Amendment Regulations 2015. As per the amendment, every service provider of the cellular mobile telephone services has to credit 1 rupees for each call drop up to 3 call drop a day to calling consumers, which happens within its network. The money should be credited to the consumer account within 4 hours for the prepaid consumer and adjusted in the monthly bill of the postpaid consumer. The agreed by the amendment reached the Delhi High Court, where they held that amendment regulation is valid. Further, the Cellular Operators Association of India approached the Honorable Supreme Court, challenged the said order ordered by the Delhi High Court. The issue was whether the 9th Amendment to the Telecom Consumer Protection Regulation 2015 is ultra-vires the sections 36 read with section 11 of the Tri-Act. Whether the infraction regulation violates the appellant's fundamental rights under the Article 14 and 19(1)(g) of the Constitution. Judgment देखते हैं. Dealing the first issue, the Honorable Supreme Court held that the particular amendment is ultra-vires to the section 36 read with section 11 of the Tri-Act. Supreme Court said that the major power of the Tri-Act is regulate to making the power which provided under the Tri-Act, and this power should be used consistently as per the Act and the rules. It was said that the regulation was not made to ensure the compliance of the trade and condition of the license, nor has to be made to lay down the standards of the quality of the service that need to comply. Hence, it is outside the purview of section 11. It was also held that this amendment does not carry out the purposes of the Act under the section 11, so it also not valid under the section 36 of the Act. Hence, it is ultra-vires the Act. The amendment violates the Article 14 19(1)(g), and it was found by the TRI that the 36% of the call drop takes place because of the fault of the consumer end, and hence the court observed that this being the case, it is clear that the service provider is made to pay all the call drops that may not be attributable to his fault, and the consumer receive the compensation for a call drop that may be attributable to the fault of the consumer itself. Hence, therefore, the imposing the strict liability to the service provider is erroneous, as in the case of the call drop, the service provider are not fully liable, and so it is arbitrary and unreasonable. नेक्स्ट वीडियो में बात करेंगे BSNL वर्सेस टेलीकॉम रेगुलेटरी अथॉरिटी ऑफ इंडिया एंड एक केस डिसाइड हुआ था 2010 को। थैंक यू सो मच।